Delivery driver Alan Colie is currently in jail for a firearms charge, despite being found to have acted in self-defense in a shooting incident that was caught on camera at a Washington, D.C. mall. He was being harassed on camera for a YouTube prank and very obviously did not find it funny. The incident was less than 30 seconds and has raised tons of questions about what qualifies as self-defense, what qualifies as threatening behavior, and what exactly happens in the aftermath of a self-defense shoot. You're gonna want to stick around for this one. Hello everyone and welcome back to the channel. The Alan Colie case is an interesting one as it is, in my opinion, not the best case for self-defense, but was ruled as self-defense nonetheless. Even so, he was charged with lower firearm charges, still ended up convicted, is still doing time, and ended up with a public defender despite having paid for concealed carry insurance. And the whole thing was caught on camera because some guys were filming it for a YouTube prank. The YouTuber, 21-year-old Tanner Cook, apparently follows people around in public places and gets into their face for his channel of about 65,000 subscribers. In this case, he happened upon Colie, who was picking up a DoorDash order. Cook, who is 6'5", and one of his friends got into Colie's personal space, holding a cell phone in his face that was repeating the message, some expletive, "Quit thinking about my twinkle," over and over again from a Google Translate app. Frankly, it's juvenile and stupid and makes me feel like I'm watching Idiocracy, but that is today's culture. We're doomed. Colie said stop a few times, tried to slap the phone away, and even tried to walk away. Cook and his friend kept following Colie, who then drew his weapon and shot.
What?
Hey, dip, quit thinking about my twinkle.
What's that mean?
Hey, dip, quit thinking about my twinkle.
No.
Hey, dip, quit thinking about my twinkle.
Get out of my face and call cops on you. Stop.
Hey, dip, quit thinking about my twinkle.
Stop!
In court, we learned that Colie almost immediately called his concealed carry insurance company, even had them on speed dial. It's been confirmed that he was a paying customer, and it's been confirmed that he was denied coverage, though we don't know why. I have heard two explanations. One is that because any claims go to insurance adjusters first, rather than lawyers, and the second is that they simply don't cover anything that could be ambiguous or questionable as a criminal act. So, Colie ended up with a public defender, and the prosecution tried to use his phone call and the denial as evidence against him in court. The call was thrown out, but not on its merits. It was only thrown out because it missed a deadline, which is pretty concerning. And so here, of course, is the part where I know people will ask me what they should do instead if they're worried about ever finding themselves in a self-defense situation, because let's face it, a lot of times it comes down to who has the better lawyer, and a public defender just ain't it. Attorneys for Freedom is an Arizona-based law firm that has started a new program called Attorneys on Retainer. The program was started by a lawyer who is also a veteran, and the program is legal in all 50 states, unlike the insurance programs out there. I have personally chatted with some of the folks on their team, talked about some of the cases they've represented, and brought up concerns around self-defense situations that I have seen people ask in the comments or in messages I've gotten. And honestly, you're better off asking them, because I am not a lawyer. They have assured me that they will take any case all the way to jury trial if that is what their client wishes, are passionate about the Second Amendment, and don't have the exclusions of an insurance company. They can represent you whether it's a criminal or civil case, even if it occurred in a gun-free zone or had other elements that would disqualify your case in the fine print of insurance companies. So if this is something that interests you, you can check them out at my link down in the description, and as a bonus, get $50 off your membership fee if you use code LibertyDoll. They also have a YouTube channel and have done a really great legal analysis of this case and some other caught on camera cases in terms of self-defense. In Colie's case, I honestly feel that he was lucky that the jury found he'd acted in self-defense. I suspect that some extenuating circumstances there came into play. For example, Cook claimed that he had no idea Colie wanted him to stop or was uncomfortable with the situation. He said that he did not read Colie's expression as being angered or uncomfortable or afraid. He admitted that he thought about stopping the prank, but not because Colie asked him to, but because he wasn't getting the right reaction for the camera. And in the end, the reaction he got was definitely not the one he expected. I don't know how you misinterpret someone saying stop and trying to walk away from you and trying to slap your phone out of their face, but I don't know, man. These kids, they're weird about their social cues. It also turns out that Cook wasn't even supposed to be there. He was already well known in the sheriff's office from numerous complaints about him and had been kicked out of the mall just the day before. He later said he was actively avoiding security that day as he wasn't supposed to be on the premises. The fact that Colie was outnumbered, much smaller, and that if you didn't know it's a prank, Cook seems pretty irrational and erratic, all worked in Colie's favor, as legally speaking, you have to take into account the totality of circumstances. The part that surprises me comes down to proportionality. Many states have laws that require you to use equal or lesser force in a self-defense situation. And in fact, one of the state's arguments was that Colie used excessive force. So, in layman's terms, if Colie had just punched the guy in the face, no one would be questioning it. But because there was a gun involved, that's what made it complicated. And presumably why his insurance company chose to drop him. Ultimately, Colie was charged with aggravated malicious wounding and 2 firearms charges. They found him not guilty of shooting Cook by means of self-defense, but guilty of unlawfully firing a gun in an occupied building, which is a Class 6 felony. The defense argued that these verdicts contradicted themselves, but both the state and the judge said that contradictory verdicts are allowed in Virginia. Colie was denied bond and has been in jail since his arrest in April. He will be sentenced later this month and faces up to 5 years in prison. Meanwhile, Cook has continued making videos and has gained about 30,000 subscribers since the incident. Now, I am not saying that Colie made the best decision in drawing and shooting Cook, but if he has been found not guilty by means of self-defense in a court of law, it does not make sense to me that he is also now a felon in that same court of law and may be serving up to 5 years. I haven't been able to find the date of his sentencing hearing, but I'm definitely going to be keeping an eye on the news for any updates, as I am really curious what the judge is going to give him in this situation. Would the outcome have been different if he didn't have a public defender? We have no way of knowing, but I'm sure a non-freebie lawyer could have helped. I'm really curious what you guys think of this down in the comments. Let me know if you think it's a good shoot, a bad shoot, justified self-defense or not. I'm really curious because I have seen both ends of the spectrum online and everything in between. Also, don't forget to like, share, and subscribe to this channel if you are new here, or even if you're not, because I've been getting a lot of complaints of YouTube deleting subscriptions. Also, ring that notification bell so you get notified 9 times out of 10 about new videos. Don't forget to vote for me in the Gundy Awards, which I will also link down in the description. And as always, thanks for tuning in, and happy shooting.